Okay, we're ready to start our discussion here. And this is the crimes subgroup meeting. That area where we've had discussion on before was regarding what crimes are included in registration. Additionally, the area of both same set of circumstances and that known as list 2 or the re-triggering offenses, all within that area. Were there any things that first Olivia had for the group? And then anything from our chairs?
Olivia's waving her hand. She's muted.
Oh. Here she has to. Okay, there you are.
You can't mute me and then ask me a question. I believe that this was the working group that brought up the judicial branch and some of the requirements and those kinds of things. I did ask the judicial branch to join us. Thank you, Karen, for taking the time to join us here as we chat through some of this, especially given some of the implications. So I did want to highlight that she has now joined us as well. Other than that, no, that's it.
I frankly can't really remember. I mean, I know we talked about the juveniles and, whether juvenile offenses, should be included or which juvenile offenses should be included. And same sort of circumstances were the main topics that we talked about last time, but I frankly can't remember what we were waiting for, if we were waiting for something to discuss that further. And if not, we maybe should discuss it further and ultimately talk about if the group wants to propose something to that effect, talk about what kind of language that would be and bring that to the main group at some point.
Okay.
Stacy, do you have anything profound on this issue?
Always, Angie,
Sorry.
always profound. No, nothing profound.
Pearls of wisdom.
Right. I'm just looking at the subgroup notes from 2 weeks ago and trying to focus the discussion there. It looks like I was not on this meeting 2 weeks ago, but it looks like false imprisonment was discussed a lot as the same set of circumstances, probable cause issue. I don't know where the group kind of landed on that. False imprisonment got some play in the requirements subgroup this morning. And so maybe we could talk a little bit about it here, although we have a lot of the same people. I don't know if the discussion is going to change that much, but that seems like, I mean, the same set of circumstances, I think, is, big. The question from Angie last time was, can we get data on same set? And noting that we had gotten some information on that in the past. Olivia and Katie, not sure where we're at on any data around this. I thought the answer was no on that.
Same set of circumstances, we have no way of documenting that.
Yeah,
at this stage.
Yep. So since we don't have data, I guess we just have this issue of the same set of circumstances. We believe, and Jim Fleming, I think you can confirm this, Minnesota is the only state in the union that has this requirement. Jim, is that your understanding?
Yes.
And Jim, did you have anything else? You had your hand.
I was just trying to recap where we were at with respect to at the last meeting about whether or not the judicial branch was interested in participating in some kind of review process about whether or not people get on or should get on the registry. It was fairly clear to me at the last meeting that the judicial branch representative indicated that they had absolutely no interest in participating in that, which I'm not, I'm certainly not advocating another branch to do something if there doesn't appear to be any appetite from the group to do that. With respect to same set of circumstances, I mean, I think what I've tried to do is articulate or throw out some possible options for people maybe to consider to see if there's something that can be done. I know that from the participants who do this work in the trenches, that being the defense attorneys, the prosecutors, the judges, it's very unpopular. Now, I understand that that's not necessarily how the other group sees it. We don't have anybody from the County Attorneys Association participating in this group, or there was just one prosecution representative who was just recently appointed a judge. So I don't know that we have any voice at the table from the other side. So it always seems like it's just a defense proposal to eliminate. So I certainly bring that forward to give some perspective about why we are presenting it. If people don't have the appetite to go there, I'm certainly willing to look at some other options on same set of circumstances. If maybe there's certain particular crimes on the registry that just seem to snare people in, as opposed to whether or not there would be sexually, whether or not they're sexual predators or have a penchant to do that. I certainly can share with you anecdotally some situations that have come up in my practice over the course of years with respect to one offense that comes to mind that kind of just captures people in, and whether or not they're even should be on the registry. And also, I don't know if we had it, but I thought that there was, when I left, some appetite to take juveniles off the registry.
So, Karen.
Thanks. Yeah, just first by way of reintroduction, I know it's been a while since we had the full group, but I am Karen Jazuski. I am the sole judicial branch representative on this work group. And just to clarify sort of my role or why I picked the subgroups I did, is that the judicial branch, for obvious reasons, stays as neutral as possible on matters of substantive law, matters of policy, who should be on, who should be off, what crimes should disqualify. That's not our role. And I try really hard to stay neutral on questions like that. So the only subgroup I had signed up for was I think it was methods, which was the one discussing the process and whether it should be a judicial process, an administrative process. And so, I have also put in a request for quite a bit of data. It's not going to be quite the data that you would hope to get from the BCA, but it might at least give us some baseline numbers about convictions for registrable offenses versus same set of circumstances. Still working on that. But I appreciate Olivia giving me the heads up that it seems like, and I know I've noticed this, each discussion kind of is bleeding into the other. So I will try to stay present for all. But please do not take my silence as disinterest on the part of the branch. It's just that is the role. I'm not going to weigh in on what the branch thinks in terms of the substantive law, but I am happy to answer any process questions. I will weigh in if I think it will impact judicial process or have a fiscal note attached to it just for information's sake. And again, still working on that body of data and hope to have that as soon as possible. Thanks.
Angie.
I don't have anything profound. I just want to mention that Representative Moeller is a prosecutor at Hennepin County. Shane Baker is a prosecutor, I think, at Candiota, although I'm not quite sure on the county. And I also prosecute, although that's not my role certainly here, but I am in our criminal division.
Okay, Stacy.
I'm just looking at the notes from last time, and just turning to juveniles. You know, when we came up with these registry issues on the CSC working group, what we found is that there was consensus on the juvenile issue, and we had reached consensus on the probable cause same set of circumstances issue. And we had language, we had statutory language drafted, and Shane Baker, who's here today, helped with some of that on this same set of circumstances. And we had come up with what we thought was a workable solution on juveniles. I wonder if, just process-wise, so we use our time efficiently, if we look at that language, and if that's where we start, or do we need to have more discussion? I'm seeing the notes from last time. It says that Brian, to put you on the spot, that you have research on juvenile recidivism, and that there's research showing that it's low recidivism rates. If we can take a look at that, and it'd be nice if we could maybe, because these issues bleed so much together, it would be nice if we could, maybe look at juveniles closely and see if this group can come to any consensus on where we're at, or what, from a policy perspective in Minnesota, what we're going to do about our kids.
Representative Moeller.
Thanks. Stacy, I really like that idea, because I'm not clear with the CSC working group recommendations what any hangups were that people might have, maybe that weren't part of that group. But so I think starting with that language that you all worked so hard on before, and trying to find out, is it unworkable for some reason that you weren't all thinking of before, seems to me to be a really good place to start. And then I also, just one other topic that's come up, that came up in our last meeting and then in another meeting, is just the title predatory offender registration. I know we've heard about just that the title perhaps being the wrong title, and I just don't want to forget that in the mix as we're talking about other changes.
Okay, Brian.
Yeah, so just following up with Stacy there. We're in the process, Katrina Dexter and Patty and I, we've had some discussions. Katrina's really putting together a PowerPoint presentation on juvenile, recidivism and victimology, and just kind of a deep dive into looking at juveniles and registration in general. I think that's going to be something we'll present to the main groups. All this, I don't know exactly how it's going to be presented and when, but so we should have some more information sooner rather than later on related to that topic. So.
Okay, Janine.
Brian, if you need help with that research, our research department can certainly pull that together. We've pulled some of that data for other issues in the past historically. So you can just talk to me offline, and happy to help with that.
That'd be great. Thanks.
Angie.
I'm forgetting, Katrina, were you also looking at what other states were doing on juveniles, or am I imagining that?
No, you're not imagining. That's correct. That's included in it.
Okay.
Yep.
So just FYI, and again, as folks have said before, SORNA is an option, but SORNA does require 14 and up. So just know that as we're having these discussions.
Well, they require 14 and up, but for certain juvenile offenses, I think our group of offenses is much broader. I think this one, I think they require it for the most serious offenses at 14 and up.
Now, did you want to see that report to the legislature on predatory offender registration reform? I can bring that up, share it if you want.
What report?
It's that the report to the legislature on predatory offender registration reform. Is that
Is that
just
coming
look-
out of the CSC working group?
yes?
Mark,
it's
is that
out
the
of-
statutory language I referenced?
Yes. So
I mean, we could as a group, maybe just look at the language that we had worked, quite a bit on last year for juveniles. We just start there and get a
Yeah.
discussion going on what that language means and what it's going to look like in practice.
yeah, and I can pull that up if you'd like, share the screen on that. Okay, here I'll pull it up. Do you see that?
I do.
It says supplement 2.
Looks familiar. I think juveniles were our first one.
Yep. If you go down, those are the 4 proposals.
Yeah, and I'll just kind of talk this through quick since our little group had a hand also in just this report. We talked about how POR naturally and organically came up when we were discussing CSC, because if we were broadening CSC criminal acts, then we were going to have more registrants. So this was the 4 focus areas that the CSC working group started to look at was juveniles, the same set of circumstances, modify the restarts, and provide a ramp off, provide an avenue for relief. We drafted language. I think it needs some work, but we came up with something. At least we wanted to give the legislature something to look at. So then this one, this first one, sorry, Mark, this first section is for same set of circumstances. Looks like we're a little out of order here. I wonder why we organized it this way. Can you find the juvenile? That's the petition for relief. Can you go up again?
On this.
Yeah, just go up. I feel like the juveniles should be right above the same set.
Oh, okay, this may be.
So they aren't actually separated out.
Oh, you're right. You're right. You're absolutely right, Olivia. It's in there. It's all in the who is required to register. That's right. So you can scroll down to or scroll up, Mark, so that we're seeing paragraph 1. There you go. Yep.
Yep, so subdivision 4 would be or adjudicated delinquent.
Yeah. Yep, that's what we took out, convicted or adjudicated delinquent. That's the kids right there. And then we just took it out of all 3 of the sections or 4 of the sections that touch on who is required to register. There's a note at the bottom around 243167 that we would need to, not at the bottom, just the bottom of that section, Mark, sorry, if you could go up, just in the italics, it says note.
Oh, there.
That we would need to have some sort of reservation that, because our group thought that registration should still be required in EJJ in certified cases. And then there was discussion of prospective versus retroactive. And I think that needs a little bit more discussion, but there's the general language. It's pretty simple. And that's for both same set and juveniles.
Are you done with that?
I'm done.
Sharon? Okay. Okay, Angie.
Oh, go ahead, Angie. Sorry.
Oh, no, I was just gonna mention that another thing we could consider, which I think Jim maybe sort of alluded to, but I might be misreading what he said. But another thing we could do if there's not a consensus on eliminating same set of circumstances completely, is it would be possible potentially to like keep it for the criminal sexual conduct offenses, or like the offenses that we thought it maybe might be more appropriate for, but not keep it for something like false imprisonment. Just a thought that that's another, way to go in between. And then I was just going to tell you, I pulled up the kind of summary from the feds for the juveniles, and it says that convictions of juveniles who are prosecuted as adults should be included, and then persons adjudicated delinquent as a juvenile for a sex offense, but only if the offender is 14 years of age or older at the time of the offense, and the offense adjudicated was comparable to or more severe than aggravated sexual abuse as defined under federal law. So it seems like that would be similar to what Stacy, what they did with the EJJ and the adult language.
Okay, Sheriff Heck.
My apologies to many of those who were in today's meeting earlier, but I'll again beat the drum of, if this is indeed a list of people that was intended to be a resource for law enforcement to access when you're looking for suspects, I don't think the victim or the victim's family is going to care if the perpetrator was a juvenile or not. They're going to want us to find who it was that committed the crime against the victim. When you have a pattern of behavior that a person has exhibited, regardless of whether they're a juvenile or an adult, that's predictive of their future behavior. So to make this an effective tool, we still would, in my opinion, want to have on there people who have committed offenses as a juvenile that would show a likelihood they're going to continue to perpetrate that behavior again. So to just say, well, we're not going to have people under 18 on there, I think misses the point of the tool and really hampers that. Again, going back to this, there should be a list of people whose behavior has indicated there's a likelihood over and above what the normal likelihood is for a person who hasn't committed an offense that they could do this again.
If I could just say one thing, go ahead.
Katrina.
Am I supposed to go now, Mark?
Yes. Yep.
Okay, I don't want to talk over somebody. Can the folks from the CSC work group speak to the EJJ youth in particular? Are we talking about EJJ youth who have their adult sentence imposed, or are we talking about including all EJJ youth, even if the individual stays in the juvenile system until their age of 21?
Jim Fleming, can you talk to that?
Oh, here you are, Jim. You'll have to unmute. Okay.
I was typing something in the chat. Could you repeat that?
Yeah, my question, Jim, was there any discussion around EJJ when you're all talking about that? Are you talking about EJJ youth who eventually have their adult sentence imposed and then would be subject to registry? Or are we talking about including all EJJ youth, even if they stay in the juvenile system throughout their whole time is successfully complete?
I don't know that it was conclusively figured out, and I'm certainly would want to comply at least with, we'd need to comply with what the feds would have, but the feds are only, it sounds to me requires that if it's a fairly serious offense, which I think, given that they're 15, there would be a presumption of certification on like a first degree, if that's what the equivalent is. Now, we didn't discuss whether or not an EJJ offense would warrant registration. I mean, be honest, we didn't bring that up, but I would certainly advocate for, if the kid finds themselves in the adult system, they should have to, they would probably have to register according to at least what the feds require. But I'm not saying I completely got my hands wrapped around what the feds require, because the language seems to be a bit broader, and then we have to fit our statutes into that language. And I don't know that answer.
Janine?
Thanks. I just wanted to go back a little bit to the past behavior is predictive, future behavior is old school research. And the science is more sophisticated now about looking at the likelihood of an individual to reoffend, not by the behavior, the nature of the behavior. And so the door that research comes in through now is different than how things were built in the past. So we can certainly put whoever on the registry that we want, and I'm not advocating one way or the other necessarily, other than if we choose to do that, our rationale for doing it should really be based on current research and the science of today, which is that it's about speaking about the offender as the predictor of future behavior, not what the offender did as predictor of future behavior, which is why it brings into question the development of an adolescent, not what the adolescent necessarily did. So we can certainly do that. I just wanted to toss that out there to just balance off some earlier comments.
My
Stacy.
experience has been,
No,
hello.
sorry.
Hey, I just wanted to just throw something in there from our experience working in the predatory offender or the predatory crime section here at the BCA, where we deal with offenders every day. And it's also internet crimes against children, which I had said in an earlier meeting, how that, those two worlds cross over significantly. I've pulled up the private data of just the 38 juvenile sex offenders who are on the predatory crimes on the registry. And some of the crimes, it's against a 10-month-old child, 5-month-old, sexual assaults against a 6-year-old. I can't see how you wouldn't want, I would want those people these kids on the registry at least, until their 10 years is up, just so I have an idea. And my experience has been that we get a heck of a lot of reoffenders. We get a heck of a lot of two-timers in a lot of the cases that we do. So I just, from working in this field for, 20 some years, we get a lot of reoffenders here. So that's just my perspective.
Okay, Stacy?
I wasn't sure who was speaking just then.
That was Josh.
I'm
Because
the special agent in charge of the predatory crime section here at the BCA.
Oh, gotcha. Okay, nice to meet you.
Yep, thanks.
yeah, they're set up. I don't know if it doesn't allow the hand raising, so it's a little more difficult to recognize them in this, so.
Yeah,
And
that's
we will
okay.
be sharing the stats that we have. I know that there was a request from the sheriff about just kind of naming some of the crimes that had been committed without private data. And so we'll be sharing what we are able to share as soon as we can with the group.
I'm sorry, Olivia, what are you gonna share? What are you guys working on?
So Sheriff Heck asked via email, I think you were on this email, as to information on the juvenile offenders and what crimes they had committed. Those de-identified crimes without their identifying information, it's fine for us to share. And so we can share that information.
And is this current registrants?
Yes.
So I guess what the thing that I wanted, the thing I raised my hand, am I free to speak? Mark?
Yes.
Okay. The point I wanted to raise my hand on was we are using the registry. This is to Sheriff Heck's comment. So I understand how the registry is used. When we know who the allegations are against, we don't need the registry, right? We're not looking for a suspect. We're not looking to clear suspects. We're not looking to locate maybe where someone is. So I guess one of my questions is the registry used when a person has made an allegation and they know that it's, John Doe and he lives there, and this happened to me. And just speaking with juveniles now, there are a lot of cases involving juveniles that we don't know who the suspect is, and so we have to use a registry to kind of vet out, like, okay, who are the juveniles living in this area?
What was that a question for?
Yeah, I'm
Yes,
sorry,
that
was it
a
not a
question
clear?
for Sheriff
Okay.
Heck.
Well,
Oh,
probably not a very good question. I guess I'm trying to understand how it's used, and if there are a lot of cases where it's like, we don't know who it is. We're just looking for a juvenile that lives in this area or maybe that area, because we have an allegation that a crime happened, but they don't know who it is or they don't know where that person is.
so Sheriff, did you want to respond?
So obviously I don't have numbers in front of me, so I can't speak conclusively about this. I would say that in my experience, the number of whodunit cases where it's a juvenile are lower than the number of whodunit cases that involve an adult. However, if I did have a case as an investigator where someone came to me and said, my offender is Billy Smith down the street, and this is what Billy did to me, it's true. We would not be going out on the registry to look for a different person because they've told us who it is. However, you could use a registry to see if Billy Smith is a registered offender and to see if he is, what his previous offense might have been. That would be very valuable information and research that I would use to kind of construct how I would approach Billy and some of the things that I would say to Billy as I was trying to close out the investigation.
Angie.
This is not why I raised my hand, but also it seems like it could be used to locate Billy if Billy wasn't at home, if there was secondary address or car information or things like that. I don't know if Sheriff Heck or the BCA can comment as far as if it's used in that way. I know there was a supervising agent on one of these calls, and I can't remember which meeting, who said that she regularly used it to supervise her offenders for that law enforcement purpose. So I think we have to recognize that it's not just about finding the stranger out in the community. And I also think we have to recognize that whatever we do, and and I think a lot of these ideas are good ideas, and it's good that we're looking at them. But whatever we do, however small we make it, we're going to have some people on there that we personally will be like, why are they on the registry? And we're going to miss some people that should be on that registry. So I just think there are limitations to what the legislature can do to help law enforcement too. So that's all.
Jim.
I mean, I seem to think that law enforcement's view is that because you have had contact or you've had a criminal sexual conduct offense happen, or you've been convicted, adjudicated, that you then there is now this proclivity that you're going to do it again. And the studies the study that I know that's out there shows a very low recidivism rate amongst juveniles. And I think that we're sort of, what we're asking is saying, look, at these classification of folks have a very low recidivism rate. And what I'm hearing from law enforcement is, well, you know, we think that because they committed this offense in the past, they'll commit it again. I mean, it almost seems to me un-American to make such an assumption, particularly amongst juveniles. Particularly when the data that we know indicates a very low recidivism rate. Now, I'm certainly open to, you know, hearing arguments about, you know, really bad juvenile offenses, but I'm going to tell you, those kids are probably getting certified.
Patty.
There's a lot of research on children with problematic sexual behaviors. We know that, I know the researcher who did the research for preschool children as young as 3. Actually, preschool children tend to have more victims. It's an experimental thing. They don't know boundaries, and they tend to almost exclusively, because they're little, victimize people that they're in direct contact with, neighbors, somebody in a daycare, somebody right there in their small little world. As they get older, they have fewer victims than an adult offender, and they almost always, it's a close relationship, a neighbor, a sibling, somebody right in their little world. And then when we started naming it children with problematic sexual behavior and getting these kids some help, the recidivism rate is very low, less than about 3% or less even. So putting these kids on an a predatory offender list is not the right place to put children. They're very different, and they shouldn't be in the same category and judged the same as an adult offender who knows better. And I think that includes, I would not even want it up to be a 14-year-old. I have 14-year-old niece and nephew, and it's like, they're very different and they need help. They need to be held accountable, and then they're least likely to reoffend than even somebody who's never had an offense in the first place. So let's go with the research as we make these decisions, not the exceptions way outside the boundary of what we know works for turning kids' lives around and helping them to never reoffend again. That's the goal. And putting them on a registry counters that purpose. It takes away everything they need to grow up healthy and strong and safe.
Representative Moeller.
Thanks. I wanted to go back a minute to the language that Stacy read from the CSC working group and then the discussion, because I think, the CSC working group talked about how EJJ and certified youth would still be subject to the registry. And when I heard Sheriff Heck and Josh talking about some of your examples of behaviors, I think those cases probably would fall under EJJ or adult certification. And I think it would be super helpful for this group. I don't practice much juvenile law at all. And so, I was trying to go back to 260B and reread that statute. I think it would be really helpful for this group to understand what offenses are generally subject for certification and for EJJ, what sex offenses are, to understand that some of those really kind of extreme cases that were mentioned probably would still have to register, at least under that proposal that was presented by the CSC working group.
Okay, we have a bit of a procedural question right now. There's been mention about input from county attorney. We do have Candy-Ojai County Attorney Shane Baker here. Technically, he's a guest, so this isn't the allotted time for that, but I'll look to the chairs to okay that. And if I don't, okay.
Hi, Shane. Yeah.
So Shane, you can unmute there.
Thank you. Yeah, I was getting the calls on Friday and about replacing Andrea and the email from Stacy. So here I am Monday. So I'm coming into it in the middle of a conversation, so that doesn't help. So just some points from first on the EJJ. When I was involved in that conversation on the CSC working group, I know my thought on that was any of them would be included. So it didn't matter if they successfully completed EJJ or not. Once it's an EJJ, you'd be subject to the registration. To Kelly's question on which offenses come in, generally speaking, 14, 15-year-olds, it's a presumption not to certify 16, 17-year-olds. It is if the offense is one that has a presumptive commit to prison based on no points. So your first degrees for every 16, 17 would be, and then it varies after that. Same set of circumstances issue. I'm curious to hear what the objection or what went into that. I know at least when I was involved with it previously, maybe the big thing that was a hiccup or a problem with it is that either wasn't a judge-made decision or it looped in a lot of cases that really was based on the charging decision. That's what triggered all this. And it seems that if a judge acquits at trial, but someone's convicted of a crime in the same instance, why should that be included? I know we in Kansas County had one where it was a contributing to the delinquency of a minor was the sentence of conviction. The criminal sexual conduct was dismissed. That person had to register. If it's dismissed for probable cause by a judge at an omnibus hearing, if prosecution discovers later there's insufficient evidence to support the registration and they want to dismiss. So all these situations, because you base it on that first complaint, doesn't matter if you dismissed everything, recharged it, and went again, you would loop in all those as potential registration offenses. So that's what created a lot of the problems as far as how you work on resolving, because either whether the judge says the evidence doesn't support the registration offense, but other charges, you're still looking at registration. And are those the people we're trying to make sure we're keeping an eye on? I guess my overarching policy perspective is it seems to be a big problem if we have a process where half the cases the judge is departing. You know, who are we, how many people are we overloading into that? And because I think those would be the people, as the sheriff talked about, we're concerned about. Where are they? What are they doing? And if they're violating the new registration requirements, they should be held accountable for that. So just initial thoughts.
Angie.
And again, I want to clarify, I don't have an issue with changing same set of circumstances. But there is a requirement that there be probable cause. And if there's a contested omnibus and there indeed is a finding of no probable cause, registration does not apply in that case.
Okay. Oh, and here we are, Katrina.
Yeah, thank you, Shane, for sharing context in regards to the CSC working group around EJJ youth. I encourage the work group to think strategically and critically about the EJJ population. The disparity rates that perpetuate the EJJ numbers are stark in our state. And so I think when we're talking about the bifurcation of the adult and juvenile world, kids are afforded the opportunity of EJJ to stay in the juvenile world. And so if we are saying that they are subject to juvenile delinquency under that status, then I think it's one of those groups we have to think critically about, especially when we know the disparity rates.
Anything else from anybody? Yes, oops.
I was just
Stacy.
wondering if, thank you, if Katrina could say more about the disparity rates, just expand on that a little.
Yeah, absolutely. Thanks for the question, Stacy. So last year during the legislature, actually, one of the benefits that we will get to learn from is that the Department of Corrections was required to include some annual statistics on EJJ specific population in our now annual report, changing from a biannual report, our performance report, to the legislature. And so there's currently right now no, overarching statewide data that I can present to you on EJJ, but local jurisdictions across the state use EJJ differently depending on the actual geographic location they're in. So depending on their actual local practice, as well as, we have many local jurisdictions looking at EJJ in particular because of the disparity rates that they're seeing in their numbers. And so a couple of our local jurisdictions are looking at those disparity rates and thinking about how are we keeping kids on probation? What's the length of time kids are staying on probation? Are we seeing kids stay on probation from the age of 14 to 21? And are we seeing success rates? What do those look like? And so on a local level, we're seeing disparity rates not only in the juveniles that are placed on EJJ status, but also in the outcome measures of those. And so when we're thinking about including those kids in, a potential population of registry, I think we have to, address the reality that there's potentially some reform that needs to be done around EJJ in general. And if we do those in silos, then I think, we're perpetuating disparity rates that we are not going to want to see for outcomes for our kids. Does that make sense?
Jim,
I think so. I guess I wonder if we're able to maybe take us, small steps on the registry and then we learn more about this research and the data we're collecting, then we come back and make a modification. I don't know if that's within the realm of possibilities, but I throw it out there.
Jim,
Just to translate or to bring some context to Katrina's remarks, I know in Ramsey County, the very high percentage of kids on EJJ are kids of color. I mean, it just unfortunately is the case. And of course, it's almost at 100% on those kids that get certified. So, I mean, that's the intended or unintended consequence, depending on one's perspective. But those are what the numbers show.
Representative Moeller.
Thanks. And I just was wondering, and I don't know if Katrina, if the data that you're starting to collect or see from the local jurisdictions talks about those disparities with respect to sex offenses. I'd be really curious to know if those disparities are existing across the board for all crimes, if they're more in other crimes. Are you seeing, I really would like to drill down and try to find out if they exist for sex offenses too.
Yeah, I can gladly do some research into that. I think one of the things specific to this group, I think, you speak directly to this in your question, Representative Mueller. Are we including sex-specific offenses, EJJ youth, or are we just blanketly saying EJJ youth? I think those are two very different populations, potentially. And so I think that's a really good question. I'll look to see if I can get some research, even if it is just potentially a couple jurisdictions, which I know have larger EJJ populations.
Okay, Angie. Oh, you need to unmute, Angie.
Sorry. I can even unmute myself and I still can't handle it. I was just going to tell you that I looked up the United States Code with respect to the juvenile offenses, the aggravated sexual abuse definition. And I'm not going to read the whole thing, but as far as the general language that the feds have is for the aggravated sexual abuse is an offense using force against the other person, threatening or placing that other person in fear that any person will be subjected to death or kidnapping And then the second provision is where somebody renders the person unconscious at the time, and they're unconscious at the time of the sexual act, or force or threat of force. Basically, it's where somebody doesn't understand being sexually abused because of being unconscious. So just those are kind of the main categories in the federal statute for the aggravated sexual abuse.
Brian,
Oh, I just don't know if it's time to shift gears yet or not, but another thing to think about, I think it falls into this group in terms of crimes, is the list 2 offenses, the crimes against the person crimes. We hit on it a little bit in the morning group about sort of, somebody had brought the idea about maybe using those as an extension for registration if somebody continues to commit person type offenses that are on the crimes against the person list, and using that to continue registration, those kinds of things. But just as a, how does everybody feel, and just thoughts on the list 2, re-triggering registration or triggering registration initially. Just background, I think speak to it a little bit, that, for instance, somebody committed a sex offense in 1980, pre-registration was not, registration didn't exist, wasn't required to register. And now in 2020, they commit a second-degree assault. They threatened their neighbor with a bat and got a second-degree assault. Now that person's going to be required to register as one example of a list 2 type offense. So
Brian, the other piece I think that you need to speak to 243.167 is also for those individuals that have completed registration and then had that conviction for a cap. So there's those 2 ways, not just those that it didn't apply to.
Right. Katie makes a good point. So let's say somebody was required to register in 2000, successfully for sex offense, and then completed that registration in 2010, now has committed a list 2 crimes against the person statute and is convicted of that. Same set of circumstances doesn't apply to the list 2 offenses. So they're convicted of that, and now that re-triggers registration. So those 2 ways are up for discussion, I guess, and people's thoughts on that in general.
Angie.
I have a history question for Katie on that one. Do you remember when 243.167 was passed and why?
Yeah, that goes back to the Katie Poyer time, looking at those old offenses, that prior past behavior of those offenders. Like Donald Blum wasn't on the registry, but had some of these types of crimes in his criminal past, is my understanding. But 2000 is when the 167 was added.
Patty.
Just to bounce off of Brian's question or thoughts, I clearly am an advocate of an adult who commits a sex offense. And if they've gone, it doesn't matter if they've gone free for 10 years and they commit another sex offense, they belong back on that registry. That's what it was designed to do. An adult offender who keeps reoffending sexually needs to be, that's a tool for law enforcement. Sheriff would like to know that that's a guy who's done it before and he's doing it again. That's what it was designed to do. I think there is an exception to children, that it gets individually based. So policy wise, I think it's difficult. I personally don't believe children fall into the same category. And if they did something really stupid when they were 13 and then they stayed clear, I don't know how I feel about going forward with it. I just think the criteria has to be different for children. But I am a big believer in sex offenders who are adults who commit these crimes and do it again. That's what the predatory, that actually falls into the nature of what I would consider predatory. And that's what it was designed to do. So I think that we need to keep that there.
Stacy.
Yeah, and just to come off of Patty's comments. I guess my thinking is, I mean, coupled with the recidivism rates of juveniles, coupled with the brain development issues that are going on, coupled with the fact that the re-trigger provisions in the statute are so broad. So as we discussed in requirements, any conviction resulting in incarceration will get you another 10. Coupled with the fact that, I totally hear what Sheriff Heck and Josh are saying about, you're assaulting, a 6-month-old. We want to know where you are. We want, and what I heard Sheriff Heck say was, you did this, there's kind of this presumption that you're going to do it again. And I think the data or the research that we see is that the recidivism is so low, but we do know where Billy is, and the fact that if the cases are so small or few that we don't know who the offender is, it's a whodunit, or we can't find that person because they're not at home at that moment. So I guess, yeah, you could look at the registry for that purpose, but with that limited access points for what it's supposed to be for, which is clearing that crime or solving the crime, the weight of the registry on the kiddos who are doing this and who are, it sounds like, and I'm not a juvenile research expert, but it sounds like if kids are offending at that age, they're likely a victim themselves of either a sex crime or a sexual act or some other physical abuse or extreme neglect. And so the victim is victimizing and the victim is not getting the help. And I think, Patty and I have talked a lot about this, but if the weight of the registry isn't outweighed by that benefit of the whodunit situation or where is Billy right now, I think it just makes it, in my mind, it's a hard thing to justify, to Patty's point that, these kids get on. I'm not saying there shouldn't be a registry and that people should not be on the registry. There are people who should be on the registry, and there are some that should probably be on for a lifetime. And if they committed it once and then they committed it again, there's certain areas of the registry where I have a decent comfort level with, but there are areas that feel too broad and too punitive. And the juveniles, the benefit that we're getting out of the whodunit situation or where's Billy right now, I don't know if that benefit is out, is if the burdens of the registry on these children who end up being on possibly for 20, 30 years or the lifetime, and not because of another sex offense. Is it worth it? Are the scales of justice, are they in line?
Sheriff Heck.
So first, I feel this conversation continues to conflate the registry with the notification. If we didn't have community notification and it was just the fact that if you commit an offense, you're going to go on a list and law enforcement is going to know about this, how many of these collateral effects, how much of this trauma or these negative consequences really are there? If it's just law enforcement knows you've done this, you're on a list, you have to report these things so we know where you are and we can keep track of you, is that truly a burden? So I feel again that these conversations are getting conflated. Also, I would ask the question respectfully, what is an acceptable level of recidivism? And, to those who say that, well, there's such a low incident recidivism, and really is it right that we're going to look at people who have committed these crimes as possibly being suspects to commit it again? Well, you can't recidivate unless you've done it once. And even if the recidivism rate is low, that still does mean that it happens, and that anecdotally, I can concur with Josh, his earlier comments. We see these people recidivate. And yeah, there's a lot of other people out there who haven't been caught or who aren't on the registry and who commit these offenses. But if someone comes to us and says, here's a crime that you need to solve, where am I going to start? I'm probably going to start with, well, gosh, who's done this before? Who has shown that they're willing to commit this crime? I'm not going to go just pick people at random. I'm going to go pick people who've done something to indicate that this is within their ability and within their psyche. And by all means, please put in place things that are going to stop children, people from doing these things over and over again. Absolutely, we need to do that. All I'm saying is it's a valuable tool for us to know who it is that's done these things in the past, so at least we have a starting place. And that holds true whether they did it as an adult or as a juvenile. And if these collateral consequences are truly an issue, I think we need to look at those and how those attach to these folks, not how they get on the registry.
Nicole.
Thank you. Sheriff Heck, I certainly appreciate that. And I mean, I think it's hard to separate out the notification from the registry because they're connected, right? And so there is the pieces about notification connected to the registry. I do think we need to treat children different than we are treating adults. And in my experience working with victims, most of the juvenile offenders that I have had experience with have been victims, and then have offended against their siblings or what have you. And so there's healing that needs to happen and services that need to happen. But when we only criminalize and put people on a registry that can really limit their access to really being successful moving forward, I think that's harmful and it's causing more harm. And in addition, I also think we have to look at the fact that it is more communities of color that are impacted by and large, which is not to say that they're, and I said this in our call earlier, it's not to say that they're the only ones that are committing these crimes, but they are the ones that are on the registry. They are the ones that fill up our prisons and our criminal justice system. And I think, we have to look at that too.
So just one thing, I do want to note that community notification is completely separate and aside from the registry. They are two separate processes. One is not necessarily used for the other or vice versa. There is a community notification process that goes through DOC for level 3 offenders only. They are not linked. The IT system, the actual registry, is not the same as community notification, and I want to be sure that that is clarified.
Thank you.
Yeah, and I'll just clarify it a little bit more here. Broad public notification only applies to level 3s. There's also a distinction there. And then most of the collateral consequences we look at from Angie's list and residency restrictions, those involve those on the registry in addition to those who have been subject to risk level assignment, including those who are subject to broad public notification as level 3s. So they do get mixed up together.
They do, and that's unfortunate because the registry is a law enforcement tool. It was not intended to be used in this manner. It was intended for the purposes that the sheriff and Patty have mentioned. And those statutes and residency restrictions, et cetera, were built upon that, not vice versa. So I do just want to be clear as to the delineation between an actual IT system used by law enforcement for law enforcement purposes and the decision by communities, by notification statutes to provide notice to communities and enforce those things.
Exactly. Angie.
I was just gonna suggest that it might be helpful to have if we're gonna be considering like the juveniles to do some kind of limitation of which juveniles should have to register, that it might be helpful to have a prosecutor who does EJJ prosecution come in to maybe our next meeting and just briefly explain more. I mean, I know we've got like a general idea of it from Mr. Baker, but I wonder if somebody who, like in Hennepin County or Ramsey County, I know they have prosecutors who do like all juvenile work, even in some other counties. So it might be helpful to just have somebody who really knows their stuff come in and talk to us about EJJ, if it's something that this was going to consider being one of the suggestions. So, and I don't know if, I know Kelly works at Hennepin County, if there's somebody she could suggest, or maybe Jim could suggest out of Ramsey County. And it wouldn't necessarily have to be a prosecutor. I guess if there's a attorney who regularly does juvenile, that could work too. I just know Scott County anyway, the public defender, and they had to do both. So that's just my suggestion for a future meeting.
Stacy.
Yeah, so when I was talking before about, you know, do the benefits outweigh the burden, I wasn't even contemplating community notification. And I think it's very important to, making sure we all understand what the difference is between community notification and the registry is very important. My comments were directed to just the registry. I want to be clear that I think that the registry itself, whether you're unleveled, leveled at 1 or 2, are that there's burdens there. And I can certainly appreciate the fact that it may be just, you know, well, it's just law enforcement knowing where you are. Well, it's more than that though, because of the way it's set up. There's punitive consequences for not complying with it. There's lengthening of time for if you have another, you know, criminal conviction. And, you know, we talked about that in the requirement groups, like, well, that's a good thing because it's indicative of their likelihood to reoffend, you know, but the question is it reoffend in a sex crime, or is it just, you know, is it just disorderly conduct? And so trying to figure out the differences there, but I see it as the registry itself, regardless of community notification, has burdens that follow registrants for 10 years at least, and in many cases for many, many years. And I think it's that I don't know what it's like to be on the registry, but I've heard from people that having to do that, and I think for children, especially getting back to the children piece, that being a, you know, predatory offender registrant is that there's a psychological weight. And again, talking with the kids, what are the benefits that we're getting out of kids? Can we get that information another way? Or are we all comfortable with putting kids on a registry at, you know, as young as, you know, whatever age, and then possibly being on for years to come because of other circumstances that may come up that have nothing to do with sex offenses?
Katrina.
Yeah, I was just gonna point out, Angie sent out a document in regards to collateral consequences found in other statutory language, and there's, I think, 5 specific to juveniles, and so I just encourage folks to look at those. I think one of them is specific to expungement. There's a couple other ones based on enhancements and things like that.
Jim,
I guess I'm fine with having, I mean, I think Mr. Baker in a very brief synopsis explained how juvenile can get on the registry and how EJJ and certification work. I would think the only benefit of having someone from Ramsey or Hennepin is that they could certainly explain, maybe not willingly, but the disproportionate number of people of color in these categories in their system. That to me would be the benefit. I think that anybody who does this work can certainly explain it. So I would, I'm happy to get somebody from Ramsey if that's what the group wants, I would do it. I'm just saying
So,
that.
I do just want to add that. Oh. Go ahead, Jim. Sorry, we can't raise our hands.
I'm just saying that anybody that's doing the work can explain how EJJ and certification works. And that could be in Greater Minnesota or in the Metro.
and
We do just want to
Olivia?
reiterate though, that on the registry side, and sorry guys, we have yet to figure out how to raise our hand. It's been years. On the registry side, the vast majority of registrants are white males. We can't speak to stats as to who's charged versus vice versa. We just do want to provide the data that we do have, and the vast majority are white males.
I'm not disputing that. I'm just talking about the EJJ and certification disparities.
Angie,
Yeah, I mean, I just think there's a difference between somebody saying, oh, it doesn't automatically apply to 14 and 15-year-olds and it does to older. I mean, that tells you some basic information about it, but I meant like somebody talking for like 10 minutes or 15 minutes about just the practical, getting into more detail on someone who's kind of an expert in EJJ. So I mean, I deal with a lot of things a little, and I know a little. I know a lot about a little and a little about a lot. And I think there are a lot of prosecutors and defense attorneys who know enough about EJJ, but there are some who are experts in that. And I think we should get somebody in here, especially if we're going to include that as part of our language. It just would be helpful, especially for people who don't prosecute or defend, to hear from someone. That's how I was thinking. It's never bad to have too much information, but it's bad to have not enough.
Katrina.
Yeah, Olivia, when you're speaking to the racial makeup of the registry, are you speaking to adults and juveniles combined? And is there any way to break down the juveniles? Lauren knows only 38 of them. I know we broke it down by age, but is there a way to break down gender or race?
We'll have to take a look. I mean, the fact is that the 38 literally took Katie hours of scrolling through and pulling stuff up and researching. And so we'll do what we can do. In terms of the percentage with regards to race, that is for overall as a group, as they have self-reported.
Okay.
So
Anything else from anyone? Are you talked out on the issue of crimes? If so, Janine? Janine?
Thanks, sorry, looking for that mute button and must be by Angie's. Just wondering around the issue of adolescents on the registry. So what would be a way to, we can certainly listen to EJJ information and gather some more input from different voices. So would it be helpful to, I guess I'm just wondering about kind of narrowing this a little bit and moving the ball further down the court of, is it about us doing a straw poll that are we even interested in looking at adolescents on there? How many want to keep them? How many don't? What are the conditions by keeping them on or keeping them off? Is it an age issue? EJJ on up? Is it about the behavior? I'm just trying to kind of like parse things out and see where we stand. And maybe Angie, if I'm stepping on toes, go ahead, tell me. Just trying to figure out what is when we keep saying kids, and I think no one wants a 7-year-old on there, but there's not 7-year-olds on there. But if we're talking about 15, 16, 17, or are we talking about 12, 13, 14, I'm just trying to see how we can chop this up a little bit to refine the conversation and the question and therefore come to a conclusion.
Okay. Sheriff Heck.
I apologize. I don't mean to derail the conversation about juvenile, and Janine beat me to raising her hand there. So if we wanted to continue that conversation, that would be fine. I guess I wanted to talk briefly about same set of circumstances. It seems to me that that language was likely put in to avoid the ability for those who were charged with a registrable offense to avoid that via a plea bargain. I'm just wondering if we can come together around some kind of consensus, or maybe we can talk about what would be the alternative to that if we were to remove same set of circumstances. Is this group okay with abandoning that idea that a person should not be able to plea bargain their way out of registration? Is there some alternative method that we could determine how that person, whether that person should or should not be on the registry? I'd like to see that somewhere down the line we kind of come to an agreement on that, because I've heard a lot of different suggestions.
Angie.
Well, in response to Janine, I was just gonna say, we could, and we can talk to Stacy and Troy about it at the next co-chairs meeting. Maybe we should put together some kind of a straw poll or doodle, whatever, Google poll or whatever those polls are. We could maybe, I view it as take juveniles off altogether, keep the most serious juveniles on, or leave it as it is. I think it's kind of, and then that middle group of keep the most serious ones on, are we going to include only prosecuted as adults? Are we going to include EJJ, which is again why I think we do need to at least have the EJJ information to decide if that's appropriate or not. And then like what levels or which Minnesota crimes would be similar to the federal ones, if we want to kind of go by that standard and go with like 14 and over with these crimes, whatever. But so we could do some kind of poll with that, and similarly to what Troy said, we could include in that, and again, at this point, probably just for this group, we could include in that then a similar thing, same set of circumstances. Get rid of it altogether, keep it on there for example, those sexual conduct offenses or the more serious offenses, and leave it as it is. So we could do some kind of poll if we think that would help us kind of move things forward more easily.
Stacy.
So Angie, thanks for that. I think those are good ideas. I think a straw poll. So we did polls. We did those in CSE when we were kind of at a place where we're a little talked out, and then it's like, okay, where do we go from here? And they were really helpful to help us figure out where the will of the group was and what the appetite was for taking things further. On the same set of circumstances that Sheriff raised, I think it would, I think you're right. That's my understanding of why it was added, is because law enforcement didn't want, from what I understand, law enforcement didn't want these crimes to be able to be pled out and not be, and then later be tracked with the registry piece. My question, and this might be for Shane and maybe Angie as well, but if we didn't have same set of circumstances, and we just had a conviction of the registrable offense, how would that change how the cases are actually prosecuted and what kind of plea bargains the prosecution's office would be interested in doing? It seems to me if you have a CSC, CSC 3, you've got probable cause, you want them to be accountable for, that and not be able to get it tossed, then there would be an appetite to fully prosecute it and take it to trial if there was no plea. But I'd be interested to hear from people who do that more, what the kind of day-to-day realities are. And Jim, maybe you could chime in there too.
Is Shane still on?
Yes, I believe so.
And actually, update, fresh off the presses, Shane is the representative for the county attorneys. So welcome, Shane.
Oh.
Welcome.
So Shane, if you want to speak to that, I mean, my view on it is, and I agree that I don't know if it's law enforcement, but I think it was the legislature's intent that people not be able to plea bargain out of the requirement. So I don't necessarily, I think over the years, probably according to what some of the presenters have said, and maybe even what Jim, I think, said last time, maybe that the charging decisions have changed because of that language. So on the one hand, if you take it all together, then the prosecutors just have to be responsible for those decisions if they're going to throw a third degree out the window to get out of having to try a case. But I do think from a, and I'm going back a ways to when I did a lot of criminal cases, it certainly, I think, is easier to plea bargain away a case. I think it's easier to kind of settle a case when you, I guess, aren't worried. You don't have to worry about that registration. I mean, it's a way that more cases might be settled for less because somebody can say, well, I'll plead guilty to this if I don't have to register, if that makes sense. I'm maybe not articulating this very well, but I think there's a lot more cases might be settled for less because the registration requirement wouldn't necessarily apply. And I don't know.
Sorry to interrupt you guys, but hot off the presses again, Katie does her magic. Here are the stats for juvenile offenders and their races. The vast majority, again, are white. There are 30 white. There are 3 Black and 3 Alaskan Native or 5 American Indian Alaskan Natives just off of a peripheral scan right now. And again, this is self-attestation, so we have no way of actually fact checking that. But while we had it, we wanted to bring it up.
Oh, okay, so our newly minted working group member, County Attorney Shane Baker, did you want to respond to that question?
Best I can, I guess, short version. Yeah, I believe it was probably instituted because the legislature didn't like that settlements were dismissing some of those charges that would have registration. How would it practically affect when it's if you're charging a CSC crime? I mean, if the really only way to avoid it is a stay of adjudication, because then they were not convicted of any offense. And that oftentimes is what we're asked to do when it's just that. When you include a registration offense with some other offense, say like false imprisonment and a domestic assault. There, it groups in this domestic assault that would probably make more sense as the crime being convicted of, but because the prosecutor, when they got in the case, put in a false imprisonment, that will always lead to registration. So that's little you can do with that under the current law without requiring registration, which would lead to more trials or for cases that really don't affect safety. It certainly is a conversation in settlements generally, is that registration piece. Whether it's look around, so who you lodge that decision maker in, who gets to decide who registers or not, or what's the same set of circumstances or not, or avenues we can go down. I can tell you in the juvenile world especially, judges will stay adjudication because they have that authority, even over prosecution objection. They will stay adjudication, regardless of the, almost regardless of the nature of the offense. So then that has the double negative benefit of a limited or compressed time they're on probation, because other rules say 6 months or 180 days with another 180 days extension, which is really harmful because if these are cases where we need more treatment or other programming, you're not going to do that in a year. You're just not going to. So, but the practical thing is that's where the judges will go. So that's troubling on those settlements. As far as, I know, pleading away a CSC for some other, the other probably big hang up we have is probably more what victims are looking for in a case. They may want it to not result in registration too. And those were hamstrung because it's there. Sometimes that's what they're wanting to do. So sometimes it's an aid because we get some kind of CSC and they know there's going to be registration. So very brief synopsis of first take on how it affects prosecution.
Okay, Katrina.
Shane, I appreciate you bringing up the stay of adjudication length around juveniles. I know that is an element of the conversation that needs to be brought in at some point, so I appreciate that. My question, and maybe Karen potentially can answer this, and then a follow-up to it. Is there, can somebody share what juvenile data has been requested? I know Stacy sent out an email suggesting maybe an Excel spreadsheet. That would be helpful for me in understanding, so I'm not potentially asking for a question that Karen's already got and is working on. And then building upon that, if there are specifics around certain things that aren't on that list, do I go through this group to get that, or would you like me to make a specific request to the judicial branch? And I'm thinking more of from this conversation that came up today, specifically around Representative Muller's question and some of those EJJ questions.
Can I respond quickly? I unearthed that request, Katrina, and I'm already asking our researcher about it. So you probably don't have to go back to her. Let's touch base on that. It sounds like you might have canceled the request. Maybe we just restart it. Okay. And then other than that, Olivia would have to remind me what else we have pending for juvenile. I don't recall seeing one. That doesn't mean it hasn't been emailed.
So the juvenile request that I have is for registry only. So it would be the juvenile registrant, the number, there was some detail that folks wanted as to the crimes that got them registered or put them on the registry. And then this past meeting, there was a request as to race data. And so we were able to pull that up. We can compile what is available and what we've slowly kind of piecemealed responses to during this period of time into a spreadsheet for folks to see. Know that we are not going to be able to provide personally identifiable information. So we can't provide age, location, those kinds of things that would help somebody identify who this individual was. But we can provide some of the limited information as to, you know, race and the crime, those kinds of things.
Right.
I hope that's what you were looking for.
Yeah, I think you answered my question that there's not one pending with the court now through this process. But certainly I can provide things like number of, well, first of all, the juvenile will be included in all the other data I already mentioned. So the number of people convicted, number of juveniles adjudicated of the registrable crimes, and then the other set of circumstances. You'll have some juvenile data there. And then if you want EJJ split out by racial statistics, we can do that. And the other was the other piece. Oh, is there any interest in any of the continue without adjudication data? I don't want to make more work for my researcher, but just if people can articulate and email to Olivia what you want, I can get it.
Perfect. Thank you, Karen. And thank you, Olivia and Katie, for providing the racial makeup of the current juvenile registrants. Appreciate that.
Yeah, that's all Katie. I'm just unmuting.
Hey, Jim.
I just wanted to follow up on sort of where the negotiation posture is, or how cases come out on when there's a sex offense or a registrable offense. And this is based on my experience in having tried cases and practiced in Greater Minnesota, and also having been in a metropolitan area. I think that in Ramsey County, our trial docket, those cases that go to trial are it's either a homicide or it's a sex offense. For the most part, I would say that it is 80% of those cases tried. Now, the breakdown sort of on a negotiation process is if the client is charged with a sex offense that called for prison, I mean, you're certainly, as the lawyer and as the prosecutor, evaluating the weight of the case based on how strong you feel your evidence would be. A negotiation point would be the amount of time actually served, if there's something that the prosecution can offer by way of a reduced amount of time if they went to trial and didn't go. And then the client is sort of weighing that against whether or not they have to register. And that seems to be on commit cases on sex offenses. That seems to be the balancing task that happens in a simple analysis on whether or not the case pleads or goes to trial. There's elements of whether or not the person has to register, but if it's a strong case, it becomes a question of the amount of time. And then the client is then told, you're going to be classified. You're also, once you're out of prison, and depending on whether or not you seek treatment. So they get all of that is explained to them. The higher percentage of cases that try, and it's because of the registry, are those cases that don't call for prison, but call for registration, where, it's just a stayed time sex offense. Those cases go to trial more oftentimes than not. Now, I'm not mean to speak for Mr. Baker, but I mean, I have every reason to believe he has this experience. Often, a lot of times, because of the nature of sex offense cases, they have sort of they change through the life of the case. Things come up, other things happen to the case that make it all of a sudden stronger or weaker. They have sort of an ebb and flow up and down. Those cases that don't call for presumptive prison, but if you're gonna plead off of that case, same set of circumstances are gonna require you to go to trial. The only way the client's not gonna trial is if they completely beat the case at trial. And those cases are at a higher percentage, and Mr. Baker can correct me if his perception is different. Those cases tend to go to trial more often. Now, with respect to juveniles, yes, the judge has the authority to stay the adjudication on a sex offense. But it's been my experience the judge doesn't do that until they've had the benefit of a psychosexual. And that decision is often made after the judge has had the benefit of looking at a psychosexual to determine if that sort of disposition risk warrants giving the kid a stay of adjudication, not warranting it. Now, I'm not certain, and I have not been, this is anecdotal, as to whether or not even those kids that have pled and have gotten stays, if their probation officer or corrections officers, in some cases, have made them register anyway.
So we can't have somebody register just because somebody says they have to. That is not allowable. That is not accurate. We do not just hand out registration forms and have people register. That is not possible. That is not legal. There has to be a relevant case attached to it.
Can I finish?
So, sure.
My perception has been where this has happened is where the probation officer has gotten the paperwork from the BCA and has complied with the registration. That's been my experience. It hasn't been universal, but I have seen it happen.
Jim, this is Katie. Can I speak to that, please? Just
Sure.
want to point out, there are times where, sure, whether it's a juvenile or an adult, it happens. It happens with people in Mark's group at the DOC, even where people will get registered. They'll fill out the paperwork only to determine that they're not required to register. That is what our staff here at the BCA does. They take that registration form, and if we go in, we make sure we have the complaint in the sentencing document to be sure that that is accurately applied. If there is a stay of adjudication, if there's a continuance for dismissal, those juveniles, we email the probation agent and send that juvenile a letter stating that they're not required to register. What we'll sometimes even see, Jim, to kind of speak to this too, is we'll see where a court might sentence, or part of the sentencing order may say that they're required to register. But if they don't meet that statutory requirement to register, we don't register them. We will delete them. We will tell law enforcement if it was Sheriff Heck, or we would tell the probation agent if it was probation agent Hennepin County. And then we let the offender know that they are not subject to registration because they don't have an offense that requires registration. And then we'd also, Jim, on that same sense, if there was a stay of adjudication or a continuance, we would tell that probation agent that should they violate and eventually become adjudicated, then we would need a registration for them, because an old registration wouldn't apply because it would come in before they were actually sentenced on that offense.
I'm not being critical of anybody. I'm just sharing with you experiences that I've had in the number of years that have come up. I can't say how many times. I know that I've had this battle, and has been with the probation officer for the most part trying to it, and then the judge backing down. I'm just saying it hasn't been, in my experience, universally applied, as you said. But I don't know how many cases it has. I'm just telling you from my experience.
Yeah, well, and if it came back to us, I mean, I can't speak to what a judge and a probation officer determine, but if we receive the paperwork at the BCA, it is our responsibility to administer the registration. And if it doesn't meet registration requirements, whether somebody has been told they have to or not, if it doesn't meet it, we would delete it. And I would want to know who these people are, if there are people that are actually registering without those offenses, those convictions.
Yeah, we have to tie those two together when they come to our system. So we would want to know if there were those issues that you were seeing on the back end and what was happening with those so that we could work to fix whatever issues were there.
Yeah, and I would repeat exactly what Katie described there, that we run into these cases fairly often with the Department of Corrections, and they get sent to Katie and then often with the assistance of Angie to sort through and figure out some of these messy details. But that's something we do fairly frequently, is have them sort of clean up the whole situation so everybody understands that only those legally required to register need to register. So, Angie.
I just wanted to clarify, so for the practices requests, those are going through Olivia and Mark, correct? I just wanted to make sure. I thought we had some agreement that it was all going to go centrally through you guys before.
Yep. And so Mark and I can figure out between the two of us who needs to get what and for what purposes. There may be some situations where the judicial branch has some things, where we may have some things where we may need to piecemeal those things together. And so if it's triaged by Mark and I, we can figure out how to get it to the right person and what will answer what. I hope that helps.
Yep, that was my recollection, but then that one that came up earlier about the court going directly to the court, I just want to make sure we are on the same page. That's supposed to be going through you and Mark.
Yeah, and there may be sometimes where the court and the BCA have to chat and figure out how to answer those questions, and we'll do the best that we can to triage that and hopefully make that easier.
Okay, thank you.
Brian.
Just a nice segue into my question related to data requests again. Angie, just to clarify, we were talking about current juvenile registrants is one thing, those that are currently still a juvenile. But I think the bigger question that came up early was those that are still subject to registration solely on the basis of a juvenile adjudication that are now in their 20s, 30s, and possibly even 40s. I think I threw out some information about a number of guys that had been in prison for failure to register, and about a quarter of that 1,800 subset was solely based on the juvenile adjudication still. So they were in prison on failure to register now as an adult, but solely based on the juvenile adjudication. So if we can, again, just as a data request, try to figure that out somehow, that would be good information as well. That might come into Stacy's spreadsheet idea about what we can get, what we can't get, what we've asked for, what we haven't, that kind of thing.
So and I want to clarify this because Katie had to dip out to pick up her kids. And obviously I'm not the data guru. So there's going to be a number of folks who are adjudicated as juveniles and then have to register for 10 years. That then ends. If during that 10-year period of time, they reoffend, they do something else, that is going to cause another change. Those are two distinct instances. There's not going to be a juvenile unless they have committed, I want to say it's murder, that is going to end up being a lifetime registrant or a 30-year registrant without another adjudication or another charge.
No, so let me clarify, Olivia. So what I'm talking about is a guy who commits a CSC3, is adjudicated at age 15, and now he's 22, fails to register, ends up in prison, or goes to jail, is incarcerated on some level. That registration is going to start over again because of that new failure to register conviction. So now he's going from 21 to 31 because of the new failure to register conviction.
Okay, so you're talking about another conviction that
not a new registration list one offense that would trigger lifetime registration, just something that's re-triggering registration, still solely based on that adjudicated offense.
And I'll have to ask Katie about that because I don't know that we track people like that. Okay. Again, because that is somebody's criminal history. I don't necessarily know that would be within the registry, but I can ask her.
Yeah, just another one to kind of get on the spreadsheet if we didn't, just to clarify. Sounds good. Thanks.
Okay. We are getting close here, about 12 minutes. Did we want to, is there anything else before we would open it up for any public comments? No, we'll start with Patty here.
I hate things that can't be solved, and it's frustrating because I've sat through 4 hours, as well as many of you, about these discussions. I'm just wondering if we can't, come up with something that we haven't talked about at all, of not putting kids on a registry, but perhaps in honor of Sheriff Heck's suggestions that they get put on a law enforcement watch list. They're kids. It doesn't go into that list. So if they do something stupid when they're 21, they're not going to get that sex thing into play, because if it was not a sex offense when they're 21, that what happened when they were youth shouldn't make them become a registered sex offender. I'm just thinking that kids don't belong on this adult sex offender registry, but it's not to say that some of them don't need to be watched. And I'm just trying to come up with something in between so that we take kids off of the adult register predatory offender, because I just can't view children as qualifying for that, and have some other consideration. And so it's just a thought, if we can think outside what we keep currently trying to change this registration law. And to me, it's like trying to make adaptations to a fax machine to do what we need today. It's maybe not the venue, not the vehicle that we need to deal with children who are different. Everything that I know about children shows that they are very different. Their brain development, their emotions, their knowledge base, and being exposed to all of this sexual content in today's culture is impacting our youth. And I'm suggesting that we want them to become successful adults and be held accountable, but change their behaviors. Putting them on the registry is not the best venue for doing that. That's just my trying to come up with something different. I'll be quiet now.
Okay. Any members of the public want to be recognized at this point? Okay. Anything else? First, Olivia, did you have anything for the conclusion?
Nope, I will get to work on some of the research that we have discussed throughout the past couple of days. I know that there were folks who wanted to see more into the 2005 research, and now I'm hearing that folks may want to hear a little bit more about the 2014 changes. And so I can start looking into those and pull up the clips that I can find. I will speak with Katie about the juvenile data, but the more that I think about it, the more difficult it's going to be, because it is historical. So there may very well be juvenile offenders who have continued to offend that we are not going to have historical data on, simply because we don't track it that way, as we've shared. So I don't necessarily know how we're going to get an all-inclusive list, if it's even possible, but I do just want to voice that right now. In terms of, I know I've received a couple of handouts from folks who have all sent me different things to send to the group, so I will send those out as well. And then tomorrow we will chat again.
Okay. Anything, Stacy, Sheriff Heck, Angie?
Yeah, I'll just add on the data request, as I said in the email, I think it's going to be really important for the legislature to understand, the information that was desired, but to help us make recommendations or decisions, and the, where we just don't track it, whether it's in the courts or BCA. And if there's other things that, you know, if you, Olivia, if you and Katie think of other things that, you know, like other data points that we haven't asked for, but that, you know, could be helpful to understanding the registry, you know, throw them on the spreadsheet. And then, you know, we'll just know that we don't have that data either, because as we, you know, as we move along to the report to the legislature, I think it's going to be, you know, just really interesting to see. We have data on some things, like we know certain things, and then there's other things that we just don't know. And so that's going to impact, you know, what we can tell the legislature on any recommendations. So I encourage you to add to it if there's other things that we haven't identified. The juvenile, all the juvenile stuff will be really important to see where we have any info or where we can't verify the info.
Yeah, so typically what we say is anything beyond clean stats as to where somebody is and the data that is in the registration requirements, anything beyond that, we're not going to have.
Yeah.
So that's typical, and that's purely because that was our orders from the legislature.
Yep.
So that's the best baseline that we can give you of that. But yes, if we bump into things that we think might be useful but can't pull or don't have, we can highlight those as well. And actually, speaking of, I do have the watermarked registration data, so I can send that out to you.
Great. And are you guys going to send something like an email summarizing the juvenile data that you read today or whatever you read out loud today?
Yes, we will put, what we're actually going to do is just put it into a cleaner spreadsheet so that folks can see it a little bit better. It's probably going to be on different pages. It's going to be broken up so that there isn't a direct comparison or a direct way to align folks. But yes, we will send out what we have on that.
And then I'll talk with Troy and Stacy at our meeting about, I'll see if I can come up with somebody that might be good to address EJJ, and we can also maybe get a survey together on Monday and get that sent out on the other questions.
Okay. Sheriff Heck, any last words?
I was just gonna second what Angie said. I think it'll be valuable for us at the co-chairs meeting to kind of come up with maybe a road plan to move this conversation forward. I think we've had a lot of really great conversation, and we should keep that momentum going forward with a plan for how we're going to get to, as Stacy mentioned, the report.
Noted for your agenda.
Oh. Okay, we are then at the end of the meeting.
Thanks, everyone.
Thanks, everyone.